Thank you all for being here today. I really appreciate you coming out. And for those folks online, thank you for joining online. Please let me know if I have a little camera here that likes to follow me around. So please let me know if it stops doing that job and we'll get that sorted out. I also have a microphone as well. So if you can hear me or you can't hear me, please let me know online. For those folks online, we do not have the ability today to hear you ask questions through online. So we have another attorney here, Sandra Gardner. She will be, she's present here and online, and she will be monitoring the chat. So she will answer the questions that are in the chat. If we can't get to all the questions today, we will please follow up with us with some emails and we can make sure we get some answers. So we're here going to start today with the Inspection of Public Records Act. My name is Blaine Moffitt. I'm the Division Director for the Government Counsel and Accountability Division. Our division is within the New Mexico Department of Justice. On just a little bit of structure before we get kind of into goals. There's a criminal side and a civil side. We fall within the civil side. And our group does a whole host of different things, and one of those things is do trainings on these. So we answer all the OMA and IPRA complaints throughout the state. We offer trainings throughout the state on these on OMA and IPRA. This is one of them. And then we do some of these trainings as well as for different agencies and other public bodies as well. So that's just a quick introduction of our division. So we'll go ahead and get started today. We have really 4 main goals of this IPRA presentation. So why is IPRA important, especially as a public policy? And then we'll go over some of the best practices that we have for different areas. What are the critical terms and procedures? And we do go over a little bit of denial letters and those types of things. What are good examples of some? What are the copying costs and fees that can be charged? And what are the exceptions to disclosure under IPRA? I do have a list of them, and then we do go through some of them a little more in detail. Some of them are pretty self-explanatory and very specific, so we won't spend a lot of time on those. So we may go through those unless there's more specific questions. So IPRA is a public policy. IPRA and OMA are similar, and the reason we like to do this presentation together is we like to call them the transparency laws. And so it's really just being able to provide the public a right to their government and having that transparency and the greatest possible information possible to the public. So they're very, very important laws. IPRA itself has the right to inspect those public records, and we will go over what public records means a little bit, and we'll go through those exceptions as we talked about, but it's really just providing that access to public records and the public to inspect those. It's really a compliance statute, and it requires a holistic approach by the entire public body, and we talk a little bit about this in best practices, but I always like to start off, there's a lot of different government agencies and government bodies, right? And so a lot of times, especially with IPRA requests, they may come into the wrong agency. So getting to know the other public bodies and agencies around the state is good. Know who those records custodians are, being able to pass that information along if something comes in, and we'll talk a little bit more about that in detail. But it takes all of us to be able to get to the heart and the spirit of IPRA. So it takes all of our government agencies and public bodies to do that. And then we'll talk a lot about records custodians, and they are the person who helps coordinates all of that. So they have a large responsibility and a big role within the Inspection of Public Records Act. I will refer to Inspection of Public Records Act as IPRA. So if you hear any acronyms and you're like, hey, Blaine, I don't know what that acronym is, please just go ahead and shout it out, and because a lot of times us lawyers like to talk in acronyms, especially with all the different statutes. So what is a public body? Public body, and I'll show you a couple things. You can't probably see it here, but I have a little laser pointer. But down here in the bottom left hand of the slide, you'll see a citation. So that specifically goes to the NMSA where these items can be found. So some of the slides will have citations on them. But you can find this definition in 1426G. And what is a public body? And then public body is defined as IPRA, and it applies to every public body, and it's a very, very broad definition. So unlike some definitions in the MSA, this one has a tendency to be a lot more broad. It's the executive, legislative, judicial branches of state and local governments and all advisory boards. So encompasses a whole host of public bodies. So it can be any from your local public body, and we'll talk a little bit about, there are a little few exceptions here and there. There's some case law that says it may include some third-party contractors, depending on how those operate. So important to note, it does not tribal or federal entities, and may include, as we just said, those private parties who are serving a public function. So what is a public record? So it's really important to keep in mind that the Inspection of Public Records Act deals with public records as a whole. So public record, as we can see in our little citation, it's 1426H, and includes all digital, physical record types, including emails, photos, social media posts, text messages, websites, and there's some questions about metadata. I'm not sure how familiar all of y'all are with that concept. I know some of us are, but there's still some kind of question about how far does that reach. But it does include all of these other types of media. It must relate to public business, so private information held by a public body, but not relating to public functions, such as a shopping list. I know most of us public employees, we are very respectful to not do our eBay or Amazon shopping on our work laptops. We don't do that, but if we were, that shopping list is likely not a public record, but the computer would be subject probably to IPRA. So just be mindful so that if you're doing that on there and someone needs to access your computer, they may see that information. Yes. Sure.
System. Does that, we have to turn that over if it's not a private, if it's not?
Well, it would depend, and the analysis would have to determine whether it's actually a public record or not. Mm-hmm. Oh, I see. Yeah, that I would say if you have an attorney, that would be a question for your records custodian and attorney specifically to those facts to make that determination. That sounds a little bit more nuanced, but if it's a public record, it's a public phone. It could be subject to IPRA, but depending on what the messages they're looking for, whether they would fall under that public record, I wouldn't be able to answer that specifically. Yeah. Yeah, they're trying to do, and we'll talk a little bit about it. It sounds like it may also involve some like litigation down the line and things like that. So yeah, and so one thing to keep in mind is that IPRA is specifically relates to what a public record is. So if it's not defined, it would be there, but that doesn't mean discovery rules are different, right? So right, just an IPRA request. Right, yeah. Yeah, I think just without knowing the specific, and I don't necessarily, yeah, I know. So I think it would just be, I would have them look at it from that angle. Is it actually public record? So, yep. So, however, with that said, just know that there should err in favor of disclosure, but again, be respectful of those people's private interests. So this can include records held on behalf of a public body, and we'll kind of have a small example on that. records the public body might not be required to create or maintain. And we'll talk a little bit more about that. And records are exempt from disclosure or not subject to retention laws. So I want to make just a quick point because this is another question that comes up often is Inspection of Public Records Act, if we don't have a record, right? Are we required to create that record? Well, no, you're not required to create that record to fill a request, right? So if you don't have that record, you can't produce it because there's no record, right, to produce. But keeping in mind that if there is an IPRA request and it comes in and there's records later, you know, the records that have to be produced are the ones at which time the request comes in. So say a year later, you now have those records, right? Well, that IPRA request is a year old, right? You don't have to go back and fill it. You know, I think one of the things that is important to keep as like a best practice, though, is that if these people are, you know, trying to get records and do those types of things, and there's especially when there's a lot of records, having those rolling, you know, record delivery systems in place is a better option, right? So you have that kind of throughout. So the other point I want to make real quick is, and can't remember if we'll talk about this a little bit more in detail, but I always like to bring it up is a question that comes up often is about IPRA and record retention, right? So just because there is not a record or there aren't records to produce under IPRA doesn't mean that there isn't a retention violation that happens. So it's important to keep in mind there are record retention laws and policies within agencies that you also have to follow for public records. So just know that the definition of public records, there are some retention records and it outlines pretty specific procedures on what records need to be retained for how long, all those different items. So make sure that the records custodian knows those and knows the internal policy of those items so that they can keep those records and provide them. So as we just talked about, litigation versus discovery, just keep in mind that litigation discovery may include records that are not subject to IPRA. It's much broader. So here's example one, and I have a few examples and we'll kind of just walk through these. Feel free to shout out the answer if you know it. An on-duty cop uses his private phone to take a picture of this duck while tending to a crime scene near a lake. The cop takes the picture of the duck because it looks unusual, sends the picture from his private phone to his friends. What do y'all think? Is that picture of this duck quacking along is that subject to IPRA? No, great. And hopefully not. Hopefully the duck didn't commit any crimes. Maybe hopefully they're not walking away with drugs or anything like that. So, but yeah, so no, the answer would typically be no. Let's take a look at this one. And I think this goes a little bit to your question. Police officers on duty and conducts an arrest when the suspect is in custody and in the back of the police car. The officer takes his personal private cell phone and photographs the stash of drugs in the suspect's car to show to either his non-police friends or his friends. Now, what do y'all think? It's a little bit more nuanced. Well, it's part of the crime scene now. And it's part of an open investigation. So it depends, right? So I think the thing is yes, that would be considered a public record. Now, whether it's subject to IPRA, it might fall under an exception to give it out. But I would say yes, even though it's on their private phone, it would be considered a public record. That's true, but it would still be a public record. But if no one knows about it, then that's also hard, right? We take people at their honesty. So, yes. Oh, great. Yes, thank you. Thank you. So, okay, I will make sure to do that. Thank you. So here's just an example of another thing about public records. Example 2, and I don't know who put this in there, but Cocopelli, I don't know, something. this other company contracts with the state to build a library. The contractor maintains those payroll records for the employees at the public library. What do y'all think? Is that a public record? Yes, I see a lot of head shaking. Yes, so that's great. That would be considered a public record, even though it's a third-party contractor. They are fulfilling that public function. And there's a very specific case called the Toomey case that goes through an analysis of what that looks like. And if it's fulfilling that, another great example, which I don't have up, I have this one up here because it's a little bit more nuanced, but another good example is a police or a jail, that's run by a private facility or private company. They're fulfilling that public function, so they would be subject to IPRA. Yes, we have a question. So the question was, does it separate between the employees as a whole or the employees who are working to construct the library? So this is if they're the example specifically is maintaining the records of the library, the employee payrolls of the library, because there'd be state employees. Yes. So the question is whether any of the employees can claim privacy. There are some exceptions, kind of redactions that you can do for certain information, but it would depend. So, great questions. We're doing okay on the repeating and hearing me? Okay, great. So records custodians, we have a little bit more time here to talk about the records custodian. So this is really the person the public body assigns and determines who is responsible for all of those public records requests. They typically, and I know most people in state government only wear one hat and do one job. None of us wear any other hats. We don't do any other kinds of jobs. We don't have any other responsibilities. But say we did, so the records custodian might also be another employee doing a full-time job. So it's just typically whoever that agency or public body is assigning to do that job, they must by statute assign and designate at least one records custodian. They can't have more. So oftentimes, you may have, like, let's say, I know our office, we have one person who I think is currently designated as the records custodian, but we have a couple other people who help with that role, because we get a lot of records requests. I would assume the city of Albuquerque would get a lot of records requests, so they may have a team that helps with that. But oftentimes, especially smaller local public bodies, it's typically just one person, and they're probably also the lawyer and the receptionist and the paralegal and everything else. So they have a lot of different roles there within some of the smaller local public bodies, but by statute, they are at least required to have one person designated. So what are their responsibilities? Because they have a lot. To coordinate search, the collection within the public bodies, all those public records, to communicate with the requester, ensure that all the compliance and IPRA deadlines are met, arrange for the inspection or delivery of records, and we'll talk a little bit more about delivery of those records and costs and fees, processing invoices for the fees, ensure the public body posts the IPRA notice, and they can testify in some instances in court about IPRA process and compliance for that agency or public body. So they have a lot of responsibility and a lot of duties that they have to meet. So one of the things that they do is post the IPRA notice and make sure that it's in compliance. So we talk a little bit here about what is an IPRA notice. It's the notice that basically gives the public and alerts the public about that agency or public body's IPRA process, procedures, fees, any other contact information, specifically the contact information for the records custodian. And it must be posted. So, one of the things is that if there's a website, should be posted that says conspicuously, but should be posted on the website should likely, if you have a physical office location, which most of you do, there should be a copy there too, posted there. And it must state these items. It must state the right to inspect, responsibilities of the public body, the procedures for requesting that information, copying fee policies if there is one. Also, if there's a policy for USB flash drives or CD production, that should be in there as well. And that record custodian's contact information, name, phone number, email. Those items should all be in that notice, every notice. So as we said, just please note that it should be at least in the office location. Also, if you're maintaining a website, please post it on the website. This goes to the spirit of IPRA. IPRA is there to be a transparency law and allow the public the opportunity to inspect all of those records. And if they don't have proper notice of what that looks like and what the process is, then we are not really following the spirit of IPRA.
Censor, so what would be a conspicuous in a place where I mean, there's no really public access?
Sure. So the question is, what happens if our office has security measures in place so there's really not public access and they have to go through a security or point check or something like that to be able to come into the office at all, correct? So two things. One is, if you have a website, definitely post it there. I would make it available. So, if there is a checkpoint and maybe there's a person, I don't know if there's a person to take in that person at the checkpoint, like to see if they need to get in. But if there is, I would just have that person make sure they have copies of it so they can hand it out if they're going to a checkpoint or something like that. So great question. So PII, and this goes a little bit to your question earlier, and the question earlier was what happens if there's some personal information. So protected personal identifier information, also known as PII, it includes a few different things. It includes all the last 4 digits of taxpayer identification numbers, financial account numbers, credit card numbers, driver's license numbers, all but the year of a person's date of birth, social security number, home street address of non-elected public employees, city, state, and zip code are public. So does not include names, addresses except as stated there, email addresses, or phone numbers. So all those don't get redacted. Right? So oftentimes this happens within redaction and not withholding, and we'll talk a little bit more about what the difference is between the two. But protected personal identifier information, PII, in these items you can redact all but the last 4 digits of a credit card number, for example, or license number, all but the year of the person's date of birth can get redacted. So in some instances, to your question a little bit earlier, it depends on what the information is. So some of it can be withheld, but not all of it. So what happens when the request is sent to the wrong custodian? This happens, and this question comes up quite often, especially in our division. We see this question a lot. A lot of people call in and ask this. Hey, this is not something that we have. We don't have these records because we're not the office that holds these records. What do we do, right? And in this, really, it should be, this is where having that knowledge of, well, what agency does hold those records? Why are you getting the request, right? So knowing who has those records and being able to pass that along is really the important part of it. So if it's sent to the right public body and just the wrong employee, just send it to the right employee. It's really important. We actually just did our own training a few weeks ago, and I made sure everybody knows who our records custodian is in the office. So when we get our own IPRA requests, everyone knows exactly who to pass it along to. So this is just a very important thing to know. Make sure you know who your records custodian is and make sure it gets passed along to that proper employee. If it's sent to the wrong public body, it's a little different because then you have to figure out which public body it is. They should have an IPRA notice, so you should be able to look at that and figure out who their records custodian is and then send it to that records custodian. Best practice is if you're going to do that, please just like give a call to that records custodian or email them, say, hey, I'm going to send you over some stuff, just giving you a heads up, you know, and so that they know to expect it, that you're sending that information. Yes. So the question was, is if you've gotten a request and you're contacting a separate public body because it's the wrong, you've inappropriately gotten a public request, and they've already said, we've already gotten the request, should I send the request anyway? I would say best practice, yes, just send it anyway, just to double down on it. So the employee needs to forward that request to the custodian promptly. You know, a lot of the timelines, and we'll talk a little bit about timeframes and the 3-day, 15 days when those start. So oftentimes those days start polling once the records custodian has gotten the record request. So that's why it's very important to send it to them promptly. If the request is wrong, public body also notify the requester in writing, explain why the records are not in the person's custody or control, records location, and name and address of the other custodian. So that's really important to do. I will tell you, more times than not, one of the main complaints that we see come into our office is that the requester has had no communication with the public body. Oftentimes when we reach out and we ask like, well, what are you looking for? I just need someone to talk to, right? So having that open line of communication and being able to tell them that information goes a long way with a lot of records requesters. So the response from the custodian, if possible, please initiate the immediate search and provides the records within that 3 days, but must permit or deny inspection within 15 calendar days. That 3 days is working days, so just so you all know. Search must encompass the records that exist as of the date of the request, and the public body is not required to search for records created after the date of request. And I do have an asterisk here that 15 calendar days, excessively broad or burdensome requests, and we'll talk a little bit about that as well. So, yes.
Say, yes, you can come in and look at records or scan it in, and then we never hear back from them. Does that constitute a sufficient?
As long as you're responding to their request and giving them the opportunity to inspect the records, there's no limit on when, if they don't want to show up, they don't have to show up, unfortunately. So yes, good. Oh, sorry, let me repeat the question for those online so I remember. So the question was, if a requester sent in the information to have requested, they provided it, they said this is when you can come inspect, they provided all the copying and all the fees and explanation and everything, and the person just never shows up, is that okay? Yes. Yes. Yeah. So the question is if there's a procurement process and they've done all the proper notices and there's a protest period and a records request comes in, does that extend the procurement period? I would say the answer is no, it wouldn't extend that, yes. Do you have a different thought on that? Okay. Mhm. Great. So 3-day letters, keep in mind that the 3-day letter, let me just go back one slide. Okay. 3-day letter, that is working days. So if the records are not available or searched, not completed within 3 days, we recommend that once you get the IPRA request, you just send that 3-day letter automatically, acknowledging you've gotten the request, you have that explanation. It informs the requester when the record should be available, or when the public body will supplement that response. That starts when the request is delivered to the records custodian. So important to keep that in mind. It's also 3 working days. Best practice generally is, if you're going to extend it, if it's a lot of records, and we'll kind of go into some of this in a little bit, but just maintain that contact every 15 to 30 days. Yes. Correct. So the question is if the records request comes in, it's 3 working days, yes. If the records request comes in, the records custodian is, say, on leave for some type of issue, sick leave, whatever it may be, does that still count? So we go back to the 3-day period starts when the request is delivered to the custodian, right? If the custodian is, say, in a car accident and they have no access, hopefully your agency would be, have enough people to say, this person, we know this person's out, so we have this person filling in, so that you can have that undue delay if it's like unforeseen circumstances, still when they get it. Does that make sense? Yeah, it's when delivered to the records custodian. But if the records custodian is out and doesn't have access to that, like say for an emergency situation, typically they would say when it's actually viewed by the records custodian. So, but hopefully, like most people, they have like people who are. Hopefully, most public bodies are cross-training, best practice cross-train. So if someone's going to be out for, like, say, paternity leave or something like that, right? You have someone covering that position, and not using that as like an excuse to not answer IPRA requests, if that makes sense. So, yes, we have another question in the back. That's a great question. So the question is whether, when the request comes in, whether that is considered day 0 or day 1. So I'll give an example. So if you were to say the request comes in Friday afternoon, right? 3 working days, right? So it would be available, it should be submitted in time to respond to on Wednesday, the following week. So this is just sort of a little timeline. We talk about 3 working days. The 15 days must permit or deny inspection within those calendar days. Note that that is calendar days and not working days. And it is, again, has the same start period. Best practice, again, is that after that time frame, every 15 to 30 days, this is where that kind of rolling production comes into play. So we had an asterisk earlier about excessively broad or burdensome, and I've kind of split these up into 2 different slides. Broadness really relates to the number of subjects, number of record owners, etc. Things that just make it really broad, and we have a couple of examples in here we'll go over. But burdensome is really a situation, and it refers to the difficulty for the public body to fulfill their IPRA responsibilities. So going back to, there's a number of factors that can go in here, such as number of pending requests. If there's 50,000 requests a year, which sometimes there might be, that's a lot, right? Especially if you've got 3 people working on those and each one's, 10,000 documents, like that can be a lot. So just keep that in mind, that number of pending requests can be burdensome. The staffing level, there's an example that I like to give. Say maybe there's a, let's say the city of, I don't know, Las Cruces has 15 people who work in just doing IPRA. That's cool. That's great, right? That'd be sweet. If that was the case, that'd be really nice. And then maybe they all pitched in and bought a lottery ticket and they won. Like, none of them would quit their job. They'd all stay. So we wouldn't have to worry about it. But say like on the off chance that they did quit and retire after they won the lottery, they got down to the one person who said, no, I don't gamble. I don't play those games. And so now it's an office of one. Well, they still have the same amount of requests and they went from 15 people to one person. That might be a staffing level problem. So that might be a really burdensome situation now for that one person to be in. So there are some other examples. So the scope of those pending IPRA requests, say there's one that's gonna, like I think the largest one that I've seen so far from anybody was something in the range of like 600,000 to 700,000 documents that they had to get out. It's a lot. Is going to take them well over 6 months to do. So some of those scopes might come into play, the technological capacity or other limitations, the extent of required redactions and legal review. This is especially true with like law enforcement and things like that, where they're having to redact video and do all of those other things. So those can be reasons for burdensome. Just note that neither broadness or burdensome justify a denial of a request. All they can do is justify an extension to respond. So yes, there's a question. Yes. So that's a great question. The question is whether you can respond to the requester and seek clarification on the request itself to maybe have them get to more specific documents. And we'll talk a little bit about this actually in an example down the line, but the simple answer is, going to the spirit of IPRA, it's to be able to provide that transparency and their right to inspect, right? So, if you need a little bit of clarification to figure out what documents they're trying to find, that is helping them get their information. So I don't see why you can't do that. So this is the part 2. So any extension beyond that 15-day period must be justified. So broad or burdensome can justify that extension, but they must designate the request in writing as excessively burdensome or broad within that 15-day period. Tell the requester that more time is needed, how much time is needed, and when the public body will respond next. This is where that best practice of 15 to 30 days comes into play. So, if you just say, hey, this is really burdensome, we've got one person, we'll get back to you. And that's it. And now it's a year later and not for anything, like that's probably not great, right? Because we have no idea what's going on. There might have been turnover in that year time period. So best practice is, if you say this is burdensome because we have one staff employee, you're requesting looks like it's going to be 200,000 records. We'll follow up with you on this date, which is 30 days from now, to give you an update of where we are. If there's production between that time and 30 days, just say, here's part of it, part A, we're calling it. We need more, we're going to need another 30 days, so on and so forth. So keeping that communication open is going to be really helpful and a really just good practice in general. Yes. The question is whether there's a max time limit or just keep communication going. No, I would just say keep communication going. There's no maximum time frame for that, but it is I guess with the caveat is don't use the justification to extend it indefinitely, right? So try to actually get through that production, understanding that there might be staffing levels and things like that, but just kind of make sure that information and the requester are kept up to date of that. So we kind of went over some of these, provide staggered production or rolling production, include the amount of employee time dedicated to the request. These are just kind of recommendations and justifications for those delays. So example 3, a requester sends the school district a public records request asking for all emails sent by the superintendent in the past year. The district records custodian responds by stating that the request is denied because it's too broad and therefore lacks reasonable specificity. What do you all think? You think that's a proper denial? I hear one yes, I hear some no's. Okay, what do y'all think? I heard you say yes. Okay, and I hear some no's. What would you say? Why would you say no? So going, oh, and we have one more comment. Yes.
Might be very burdensome.
Okay, great. So the answers for yes, it's a proper denial, where that it is asking for, it's broad in the sense it's asking for all emails of this one particular person. So it's not necessarily reasonably particular or specific. The other answers were that a broader burdensome request can't just mean a denial, number one, and number two, that in fact it is not really broad. It may be burdensome in the sense that it's a lot of emails, but it's fairly specific. I would tend to agree that it is not a good proper denial. So it would say it's also not broad. Even though it is all emails, this is an instance where you could respond back to the requester and say, is there a specific time frame or emails you're looking for? Is it pertaining to something specific? Like say there was, they're really looking for emails between the superintendent and this one particular person, right? Well, you might be able to narrow that search down a little bit. But if they really want all the emails, you can do that. It might take a while, but it is within the past year. So you would just calculate that. So it's within a set time frame for a specific person. Yes. It could, but yes. So the question is whether it be considered phishing. Yes, it could be considered phishing, but unfortunately, IPRA doesn't contemplate phishing itself. So it's just a records request. So example 4, this is a little bit different based on the last example. The requester sends the school district an IPRA request asking for all emails related to the superintendent in the past year. The district's records or custodian response stating that it's denied because it lacks reasonable particularity. What do y'all think? Is this any different? See some head shaking no's. I see. So I would say that there's a particular word in here, related, where is it? Related to, right? What does that mean? What does that mean? Does that mean every email the school has that mentions the superintendent by name, by title, by, that they're CC'd on? Like, what does that mean? That could be really broad, right? So I think, making sure that it is reasonably a little bit more particular. It is within the past year, so at least that is good, but this would take some analysis to figure out, what would be the proper procedure here. Best practice, I would probably do that in that instance, yes. So the question is, if you reach out to the records requester to ask them if they agree with the clarification, I would say yes. If you're asking them to clarify, hey, what do you mean by, in this example, what do you mean by related to? Are you looking for something more specific, right? Are you looking for communications between people or something like that, right? And they email back a response. I think it's great to have confirmation. My understanding is by this, you're looking for this, we'll adjust for this, right? So I think you can, and that's a good practice to have. But I think this is a little bit less certain that it's not necessarily particular enough, right? Because we don't really know what that could be. That's kind of open in the air of what do they mean by related to. I say, so the question was whether you would still deny it or reach out to them. I would say best practice is reach out to them to try to get clarification, yes. So the question would be, if they never respond, would you just deny it in this instance? Well, if you can't understand the part of getting an IPRA request is you have to know what records they're requesting, right? And if you can't figure out what requested, you could certainly respond to this and do a record search. It'd probably be pretty burdensome to find that, but I would say just to try to do it, right? Try to respond to it the best you can. Yes. So the question is is there a time frame for a lack of a response for a requester? I would say that IPRA does not contemplate a lack of response from requester. So like you would just need to, it's an IPRA request, and then they should be giving you all their contact information, hopefully to fulfill that request. So you would need to fulfill that request. Mm-hmm. No, no. So the question is, would you close it out? No, I wouldn't close it out. I would still try to respond to their request as best you can. Well, no. So in this particular request, so the question is, would it just go on for years? Not necessarily. So if they're asking for all emails related to the superintendent in the past year, you would just produce those records in the past year. Yes.
You don't respond, right? We're going with the idea that you ask them for more particularity, they don't respond to that. So you should just produce every email that you think is related to this. And then
Yes.
based on your understanding of what that might be.
Yes.
So the next step would be if they ask you for something that you don't understand, it's not as clear as all emails for intended, something like, everything you've got that I'm in, right? Something like that. Or something vague.
Right. It's a little vague. Mm-hmm. Well, if there are records that are not responsive to that, then you don't have to obviously produce those records because you have nothing to produce.
Okay, so-
But if you have records that are producible, you should produce those records because that's what IPRA requires. Yes.
If there's been more discussion about maybe charging fees for the electronic records or changing the fee schedule.
Yeah, I'm not privy to whether there's been discussion amongst the legislatures of that of changing those fees, but certainly that you're not the first person who's stated that quandary. And are they able to hear me? Okay.
If you want to do it.
All right. If those folks online, we've been having some technical difficulties. If you can hear me, please go ahead and let us know in the chat. So yes, I'm not sure whether the legislatures had discussions to update that, to take that into consideration. But as the way IPRA is written currently, that's not there's no contemplation of that. That it's an understanding that that's a duty of the public, of the state employees and the public bodies as a whole, that they just have to fulfill, regardless of whatever time constraints it provides. So, is there any, are they able to hear me now? Okay, great. Okay, thank you for patiently waiting. We've got our slides back up, so let me go ahead and get this going. Okay. The clicker's not working. Ah, I got it. I'll try to plug this in and not move anything. If not, we can do it by hand. Okay. There we go. Perfect. Okay. So here's the fees, paper records, actual cost of transmitting those copies, reasonable fees for copying. Generally no more than $1 per printed page. Electronic records, actual costs of transmitting those copies. Actual cost of downloading copies to the CD, so that's where that fee comes into play. So if you're downloading it to that CD or flash drive, USB drive, whatever folks are calling it these days. So local school district implements a new IPRA fee policy. The district charges 50 cents for all printed pages, 25 cents for each page of electronic records. We've kind of gone over some of these. Let's talk about this example. The county provides 150 pages of printed records to John Doe in response to his IPRA request. The county decided to redact a large portion of these records because of the time and expense involved with the custodian having to make these redactions. The county charges an additional $25 redaction fee to recover its personnel costs. The $25 represents the county's actual cost of making the redactions. What do y'all think? Is that an appropriate fee to charge? See, pretty much everybody's shaking their head no. So great, that's the correct answer. Correct, per IPRA, yes. Yeah, yes. So, okay, we'll talk a little bit about denial of requests and kind of the proper process procedures. So a denial is both a withholding and redacting a record altogether. There must be a written explanation, also called a denial letter, and we'll kind of go over an example of that. It must be provided within that 15-day time period, which starts when the record custodian receives the request. Obviously, we've talked already about the excessively broad and burdensome exception there. If it's not fulfilled and no denial letter is given, it may be deemed denied after 15 days. So that's why we go back to one of the questions earlier. Can we just close it out? No, because it will be deemed denied. And if you do that and there's an improper denial, there are tons and tons of monetary penalties you'll likely have to pay, which you're not going to want to pay. If no written explanation is given, then damages are possible, and we talked a little bit about that, is up to $100 per day until written explanation is provided. That can amount to a lot, lots of money. And that does accrue from the date of non-compliance, so important note to keep that in mind. So what is the content of the denial letter? It describes the record sought, cites a particular exception for each record withheld or redacted within a record, and it lists the names and titles of persons responsible for the denial. A county receives a request for draft ordinance that is currently being drafted by the subcommittees. The county denies the request, saying our policy is not to release draft ordinances until they're presented to the county commission. We also are denying the request because releasing this draft could be confusing and mislead the public because it's not final. What do y'all think? You think that they don't have to release that draft? What do you think? Do you think they should provide that draft? Yes, I see one no and I see quite a few yeses. So yes, they should be providing that draft, even though it's a draft. You can label it as a draft, but if you have the record, you should be providing that draft. You cannot use a policy as a reason to deny a records request. Yes.
Stuff on the draft that's if they get into the final, so if the public is complaining about something that's not even gonna be in the final, you know, that's, that can be I mean, just a waste of time, and that's it.
And so the comment was that there might be things in the final part that are in the draft that aren't in the final part, and the answer is yes, but if the record exists and it's a draft, it still has to be provided. Yes. If it's a draft, that's a public record, which it would likely be once it's created, it's a draft. So redactions. Redaction is removing the exempt information from a record. Oftentimes you'll see redactions with PII. You know, the most common are those. Certain exempt information for law enforcement records, we see this a lot, especially there's certain requirements under the exception rules for body cam footage and other things like that. Generally speaking, it's a best practice to redact before withholding. There are some instances where withholding the entire record is appropriate, and we'll go through some of those. But generally speaking, if there's information in there that can be redacted or needs to be redacted, redact it first before actually withholding the entire record. So here's an example of a redaction. This is one that I like to say is I call it the CIA redaction. So this is one that often if you submit a FOIA request and you go to some federal agency, they'll typically just give you a document just like this. This is not what IPRA contemplates. This is a bad example of a redaction. This is a much better example of a redaction. For whatever reason, this person sent a letter with their date of birth and all of the PII information in it, so that's great. But, you know, so this is a much better redaction. We're redacting only the information we need to, otherwise the rest of the letter is available. So this is more of what IPRA contemplates. Here's a denial example of a denial letter. Dear John Doe, on May 2nd, 2020, we received your request to review your records. We're denying this request. Sincerely, Records Custodian. Few things, and I have arrows on here just to point them out. We received your request. We have no information on what the request actually is. We have no explanation of why the request is being denied. It's also on May 2nd, and they're not sending this out till August 4th, which is a long time. You know, it's a lot of months later. And then they just sign it Records Custodian. We have no idea who made the determination, nothing. So this is a much better example of a good denial letter. May 2nd, again, 2021, they responded within May 4th. That's within even the 3 days, which is wonderful. They actually have the request in here, all letters of recommendation in connection with Jane Roe's employment application. They've identified the areas that they cannot permit inspection. They accept it from that disclosure. They cite to the section even within IPRA, which pertains to those letters for withholding. And then the individual is responsible for this, and they tell who it is, the agency counsel and the records custodian, and then they just sign it Records Custodian. So this is a really, really good example of what a denial letter should look like. So moving on, and I want to be respectful of y'all's time so we can make sure we get to OMA as well. IPRA exceptions, there are quite a few of them, and then this one is interesting and a little bit different than OMA with its exceptions. But there are about 12 of them, and then there's multiple exceptions to one record. Redactions, it does allow but not require redactions. But there are some other laws to keep in mind that may require those redactions or withholdings. Withholding, again, RIPRA allows but doesn't require, but there are other laws that may do that. And so much of the review of each record to determine which is exempt, or maybe there's only a portion of the record that's exempt. So here are the different exceptions, and I have each one of these in the slides, and so we'll go through some of them, and I'm happy to kind of take questions along the way. But just, I always note the last one here, part L, as otherwise provided by law. There is a general one here. There are a lot of laws that have either confidentiality in them, redactions, withholding in them, those types of things, federal, state, you name it. So just keep that in mind, that while something might not fall under an exception here, it might fall under here, or it might fall under an exception, multiple of these exceptions. So physical and mental examinations, medical treatment, this is typically very personal information. Person sought or received mental or medical examination or treatment. It's pertaining to, which suggests a very broad scope. Because of the sensitivity of these items, typically redaction is usually not sufficient. So the best practice is to withhold medical records. Some of these records might also fall under HIPAA and other types of exceptions, so just keep that in mind. That's why typical best practice for those is to withhold. Letters of reference concerning employment does not require disclosure of who provided reference or who a reference was for. Again, these can be kind of more personal records, so withhold the entire record is the best practice. This is one we get more questions on, and this one can get kind of complicated, which is why I have the best practice as blank on here. So letters of memoranda and matters of opinion in personnel files or student cumulative files. Student cumulative files are a little unique, so because they could fall under FERPA, depending on what it is, so just keep that in mind. But we'll talk a little bit more about just the employee files. The personnel files. So it applies to the whole record that contains both facts and opinion, but only the opinions, not facts, are shielded from disclosure. So just keep that in mind, that when you're dealing with facts of a personnel file, for example, like the personal comments on someone's personnel files are what falls under this exception. There is some new case law out, and which is why I take away this best practice, because we may want to update this slide about redactions versus withholding on personnel files, because oftentimes what happens is you'll have a personnel file and someone will handwrite notes so that they can withhold the record and withhold the document. There's some case law on that that's more recent. So I would say my best advice at this point would be talk to your own agency counsel to help make that determination about what actually gets redacted or withheld. But just know that it is specifically for opinions and not facts of an employee record.
Evaluation, is that opinion or fact?
So if it's an evaluation and it's a matter of opinion, it would likely fall under this exception. But if it's a fact of their personnel file, like, so for example, maybe you have like their name, address, those types of things, some of that would be redacted, right, on that like basic form. Those would be facts within that file system. Yes. Does the opinion section only apply to personnel files? I guess what other, because in this instance, the exception is specifically, yes, this would only fall for opinions within personnel files, yes. So the question is, if someone had a resignation letter and they stated opinions within that file about others or things, whether that would be redacted. I would rely on y'all's counsel to make that determination, but it's possible that it could fall under this exception for redaction, but it depends kind of what was said and what the record actually is and whether it's a personnel file record. Did you have anything to add on that one, Sandra? Right. Yeah, and that's where having that counsel or the records custodian evaluated under that exception would be key, right? Just without knowing the personal facts of each part. Okay, let's go to the next one. Law enforcement records. We have a couple of slides on law enforcement records. Oftentimes we give this presentation, and there's a lot of law enforcement agencies that come to these presentations. These are pretty specific, and there are a lot of other state laws and that apply, that where this one doesn't apply, there's a lot of other state laws that apply, especially like victims records or Victims Act and things like that. So evidence in connection with criminal investigations or prosecutions, it includes inactive or closed investigations if otherwise meeting requirements of this exception. It's not necessarily specific to that agency. So anything held by law enforcement and prosecutorial agencies, held by public bodies with an obligation to report, held by public bodies, turned over to or requested by the law enforcement or prosecutorial bodies. Specific procedures apply to requests for audio and video law enforcement records. And we'll talk about that a little bit in the next slide. So really and truly, this part is about protecting confidential sources, methods, and information. So you can redact names, and I'm not going to read this whole part, but names, addresses, contact information for victims, non-law enforcement witnesses. They're not exempt after the suspect is actually charged with the crime. So that's important to keep in mind. You may redact visual depictions, and this goes back to the video recordings of dead bodies, great bodily harm, intimate body parts, notification of death to family or victim, except for on-site viewing of the audio or video. So that's where a lot of people get tripped up, is some people want to see this in person. If they're able to do so, they can allow that, but they don't have to redact it. Otherwise, it has to be redacted out of the video, which is why a lot of times law enforcement records take a long time to get and respond to IPRA requests, is because they have to go through and redact all that in video and audio. Again, may redact any information falling under any other exception. The Victims Act is one of those that comes up often, and it applies to the extent the records contain information, and you cannot redact the entire record. So it's mostly redaction. Best practice is always redact these, don't withhold them. I don't know if there's any specific questions on law enforcement. Sometimes we get those, but I don't know if we have a lot of law enforcement in our audience today. Yes. Well, it depends. So yes, they may redact visual depictions of these things, but oftentimes they do. In most of these places, they have some, there's some other laws that apply to those types of things. So it's going to get redacted pretty much all the time. So yes. Confidential Materials Act, this is very specific. So this is particularly permits any library, college, university, museum for its political subdivisions keep confidential materials of historical or educational value on which the donor or seller has imposed restrictions. This is not something that typically comes up a lot, but it's very specific, and think this has come up one time in the presentations I've done for a library person. And so this one's pretty self-explanatory in the way it works. Trade secrets, this one's a little bit trickier. This comes up from time to time, typically with like those third-party contractor agreements and what is a trade secret. So really the main issue is, can the public body claim a trade secret for its own records? Generally, no. How and when should public bodies determine, if not subject to disclosure, with the third party seeking to keep it confidential? So really and truly, like, this needs a full explanation from legal counsel of why it's a trade secret. There are a lot of federal laws that deal with this part specifically, so there needs to be an explanation if it's going to be withheld. And that's where you'll see the Uniform Trade Secrets Act. Generally the answer is no, but it's typically when private entities assert these protections, which under like NDAs, non-disclosure agreements, they might have some of these protections. But I would say if you ever run into this instance where you're contracted with a third party, maybe for software, other things like that, have their legal counsel have a kind of determination of what that trade secret is, so that you can rely on their counsel's explanation of why it falls under this exception. It's a pretty specific exception. Yes.
Most of the people that work in my office, we're not necessarily experts in the matter. We're dealing with paperwork, permits, that kind of thing. So would we need to have like a third-party expert to help us out determine if something is confidential or not? If you know what I mean, is we might not have the expertise in office to that the applicant has.
Sure. So the question is when making determinations of whether something's confidential or falls under these exceptions, we don't necessarily always have the expertise to do it. And I would say, yes, if you're able to get, either outside counsel to help with those determinations or those types of things like that, that's good. There are public bodies who do have that. They do contract with law firms or things of that nature to help with those determinations. Attorney-client privileged information. I think most of us are probably pretty familiar with attorney-client privilege. We see it asserted all the time on TV shows. So that's something that most of us are pretty familiar with. The privilege applies to those communications made to facilitate the rendition of legal services. So it's between the attorney and the client. It does extend to the staff of the attorney and high-level staff of the client. These are specifically exempted in IPRA, and it doesn't mean that all other privileges don't apply. The answer is redact those records or withhold them if you can. This one is very self-explanatory, which is why you see no explanation on it. Long-range or strategic business plans for public hospitals discussed in properly closed meeting. It's very specific, and it only deals with public hospitals. Unless there's specific questions, the next few ones I'll just kind of, because they're very, very specific exceptions. Tactical response plans. The only thing I'd like to note on this is it only applies to a plan or procedure and not the technical information of tactical response plans. This is a hard exception, especially with secure facilities, trying to figure out camera angles and those types of things. So this is an area where if you have something that might fall under this exception, heavily rely on your legal analysis to make a determination of whether this exception applies. Cybersecurity and sensitive information. I left this one in here because it's sort of a broader exception that just plans and procedures, and it deals more with everything's moving online, and there's a lot of records that are stored or transmitted using technological systems. So those internal, external audits of those systems could reveal vulnerabilities and compromise those systems or those accesses. So it's a really important thing. So it's kind of a more unsettled area of IPRA at the moment, especially with like metadata. You know, people are asking about, you know, I want to see the code, right, for your site, right? That could be a lot of sensitive information and allow people to get into your closed systems if they have access. So this is sort of a more unsettled area right now of how far does that go? But just know that there is some protection within IPRA considering that. And then funding applications and scoring materials. These are same things with the procurement, closed and closed bids. There is some confidentiality rules within the procurement code, so those would fall under that as well. And then we get to the catch-all one, which is as otherwise provided by law, Part L. It includes statute, court rule, agency rule, constitution, federal rule. Does not mean our policy. Does not mean our administrative rules, our public policy, or a rule of reason. This is why we've always done it this way. That doesn't count. So otherwise by law, some ones that we see very often and you might recognize, so informer identity, health information, attorney work product, HIPAA, victims' rights, and FERPA. Those are typically the ones that we see the most often, especially with school records, especially with law enforcement records. Medical records, because we have a lot of healthcare systems here. So those are typically the most ones, but just keep in mind that there are a lot of other state and federal laws that might require confidentiality or redaction or withholding certain records. This is where the legal analysis, it comes into play a lot to determine what, if anything, applies there. Oftentimes records custodians, I don't know how they could be an expert in every law in the country. That would be pretty hard. So, but somehow they're asked to do that. So, okay. So, and we'll wrap up here that we're getting close to the end. So I appreciate y'all's patience. How is IPRA enforced? The court can award damages. We talked a little bit about those damages as $100 per day paid by the public body. They can also award attorney's fees to anyone whose record has been denied and is successful in that court. The cost of it can be very, very, very expensive. It's $100 per day from that time that it was improperly denied. So you can imagine if it's 5 years ago, it's a lot of money. So, yes. So the person whose IPRA request is violated. Well, it's very possible. I can't opine on to whether individuals are doing that, but you know, it does go to them. Yes. Mm-hmm. So who's in charge with enforcing this? Our office, the Attorney General, statutorily obligated to enforce it. Specifically, our division looks into these matters. There is a complaint process, and it is intended to be constructive. So our division, we have a portal on our website. So if there are any OMA IPRA complaints, you can obviously submit those through our website, and we can take a look at them. But we all may bring court action against public bodies. District attorneys can do that depending, and then any person whose written request is denied can obviously get their own attorney or do it themselves and bring an action in district court. Yes. So the question is whether there's a mediation process in what avenue?
The agency doesn't agree with the requester that And instead of it going to court, could there be another alternative?
Sure. So the question is, if there's a disagreement between the agency and the requester, could there be an alternative to court? Yes, there can be an alternative to court action, but they do still have the right under the law to file a court action. So just an overview of some of the best practices for IPRA. Always allow inspection of the records. You know, we want to make sure we go to the spirit of IPRA, which is transparency and allowing the public the greatest disclosure possible. So goal is to disclose, not withhold. So just keep that in mind. Always have procedures in place. Make sure everybody's hopefully cross-trained. So if someone leaves, there's always, you know, I know there's turnover. Make sure someone else who comes into that role knows the process and the procedure. Have at least one person tracking all the requests and responses, i.e. the records custodian. You are required to have one. Maintain as much communication with the requester as you can. That's always super helpful. I know a lot of people, they just want to be heard. So be reasonable. We're all humans. We all make mistakes. We all do, you know, stuff. So I just think, you know, just make sure we're reasonable. We hear people. Try to resolve all those oral requests informally, but document the responses. If you withhold or redact, send a full denial letter. That's always a good practice to be in and do. And then when in doubt, please consult your attorney, but do so without copying that requester so you can have that attorney-client privileged communication. So are there, and then I know there's some questions, so yes. 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 So the question is whether, if you're sending redacted documents, should you send clarification on why you're redacting? Yes, you should be sending clarification. These items are redacted because of this. Yeah. Or they fall under this exception, or this is PII, or whatever. Yes. Sorry. So the question is, can you just have a disclosure statement at the bottom? I would say best practice is explain why you're redacting those records and not having just a general blanket statement. Yes. I guess I'm not understanding the question. Oh, I see. So the question is whether should we have the explanation written in where the redaction happens, or should we have it in the letter? I would say best practice, I'll just go back, would be if you're going to redact or withhold, send that denial letter with an explanation. So it'd be sort of like almost like a cover letter to the documents that you're sending out. And then have that explanation of, like, you know, these areas were redacted because they include social security numbers under this exception. Yes. Yes. I see. So the question is if people come in to inspect the records, can they bring in recording devices or take pictures of those records? So if they're coming in, it's a public record, it's a public record. So if they want to take a picture of a public record, I don't see why you would have that problem. So that would be different. So if it's a law enforcement video, there are some other things in that exception that might prevent them from doing that, from sitting there recording a video of a video, because otherwise that information would likely have to be redacted under other laws. So yes. So the question is whether if they come in to review the records and there are opinions or notes on those records, I'm assuming like personnel files and things like that. So if they would fall under that exception and can be withheld or redacted, then you can withhold them from the visual inspection of records because they fall under the exception, but you'd have to explain that to them. But if you just go in and write stuff on the document so they can't inspect anything, now I would say that's very problematic. So, yes. Mm-hmm. It's not a personnel file. Yeah, so if a committee member expresses an opinion on a document, that wouldn't fall under that exception, so you can't, that's just part of a public record. Yes. Yes. Sorry, I misunderstood your question. Okay. Thank you for the, thank you for the extra explanation. I appreciate it. Any other questions online that we have? Okay. All right, well, we'll take maybe like 5 or 10 minute break, and then we'll switch over to OMA. If you have any questions, please don't hesitate to reach out to our office. All right, so thank you all for coming back. We're gonna get started on the Open Meetings Act, also referred to as OMA. And so I don't need to do another introduction. I'm still the same Blaine Moffitt with the GCA group. So we'll just get right into it. So presentation goals. We have a few goals today that we're hoping to achieve. One is understand why OMA is important, again, as a public policy and who is actually subject to it. Explain the requirements for notices, agenda, minutes, etc. Identify any exceptions to OMA meetings. There are 10 of those, and we'll talk through some of those requirements to close a meeting, aka executive session. Not exactly sure where that term came from, but we call it in closed session was the technical term in OMA, and understand the consequences of non-compliance. So the origin of the Open Meetings Act was originally done in 1959, and it has been expanded and increased over time. It was last amended in 2013, over 10 years ago, so it's probably due for an update, as we'll talk a little bit about. Things have changed in the last 10 years. I know I certainly have. OMA is a public policy. Its public is entitled, again, to the greatest possible information about government affairs and officials. We depend on our electorate. We have legislatures, we have, elected officials. Our office, we work for the elected official of the Attorney General. And so, it's good to have these transparency laws to make sure the public understands what the government does and how they're doing things. So all the meetings of a public body are public meetings, and anyone can attend and listen. We'll go over a little bit more about that. Men must make reasonable efforts to accommodate audio and video recordings. So oftentimes we get some questions about that. Really and truly, that means audio, video recordings of people who want to come in and record it, like the media and those types of things. So that's where that comes into play. So who's subject to OMA? This is really a three test requirement. Be a policymaking body, establish a quorum, and have that discussion of formulating public policy or taking formal action as a body. So that discussion of public business. So that's when you're subject to OMA. And we'll go a little bit into that. I know a question that comes up often, and I need more slides on this, but I will talk a little bit more about rolling quorums, what that means. I call them inadvertent quorums. Some people talk about that. We'll talk a little bit more about what that means. And I have some examples. Policymaking bodies are any board, commission, administrative, adjudicatory board, or other policymaking body of any state agency or political subdivision. So it includes a lot of folks throughout the state. A lot of folks are subject to OMA. It applies to those decision-making bodies. Any body that's created by statute is subject to OMA. There's a lot of public bodies created by statute, and they talk about quorums. Purely advisory bodies and committees are typically not included, but some are. This is oftentimes like, so I'll give a good example of, let's say a public policy making body wants to think about creating rules or legislative action. They might create a subcommittee to do that research and do all those things to be able to bring it to the board. That subcommittee most typically is not subject to OMA. It can be, and we'll talk a little bit about why that might happen. But predominantly, if there's a quorum, right? So what does a quorum mean? It's most often the majority unless otherwise defined in statute. What does majority mean? Say there's a public body, 7 people. 4 people would be a majority. That's a pretty simple majority rule. So that means that's what's required to have a quorum. Once you have a quorum, now we have a meeting. If we're a public body, now we have a quorum and we're going to talk about our policies and those types of things. Now we're having a meeting, right? So if we had 5 people and Stephanie and Sandra and I were all on the board, 3 people, guess what? That's a quorum. So now we're having a meeting. Luckily, we're not a public body, so that's great. So, you know, those are how quorums are done. Otherwise, in statute, I have seen some statutes, and there are some, so just be aware that if your statute specifically says what a quorum is, that's what your quorum is. So you may have a statute that says we have a body, same 7 people, 4 might be the simple majority quorum, but your statute says 6 is a quorum. Then you need 6. So it's unfortunate, but you can't just go by with 4. So members not present together at the same time and place, and we'll talk more about rolling quorums here because this is where I need to add some slides in. Separate conversations means in person, telephone, emails. That's the big one. If you send a bunch of emails back and forth and it's amongst all the people, guess what? You're having a rolling quorum. So, you know, best thing to do is typically like staff, if they need to say, you know, like let them the committee know or let the board know an item, the staff should BCC. Typically send it to the chair, BCC all the other members. So that way people don't accidentally reply all. Happens all the time. Don't accidentally reply all. Now you've got a rolling quorum problem. So something to keep in mind, rolling quorums do mean can be in person, telephone. Question that comes up quite often on rolling quorums is what I like to proposition as like a straw man example. So say I'm going to pick on Sandra a little bit today, but say Sandra is my executive director and Stephanie are board members of a 3-member board. And I go to Sandra and I say, Sandra, what do you think Stephanie thinks about this? And Sandra says, well, let me go find out. And she goes and talks to Stephanie. And then Stephanie comes back and talks to Sandra. And then Sandra comes back and talks to me and says, well, Stephanie said this and she wants to know this. And then I tell, and we have this back and forth, right? We're using Sandra sort of as the straw person to have this conversation, right? OMA doesn't specifically talk about that scenario, but that would very much, you're basically using someone to create a rolling quorum. Right, so that's a specific example that oftentimes comes up. Don't do that. Trying to think what else. Typically, often questions of rolling quorums come up because this is an area that I see a lot of people around the state have these questions. So, kind of the main thing to keep in mind in best practice is if you're going to have conversations, you know, save policy forming, public policy forming, public business conversations to the meeting. That's what the meeting is for, is to have those discussions, to have that conversation among the board members or the city council or whatever. It's to have that conversation there, right? You don't want to have these instances where you're having all these discussions ahead of time to make sure everybody votes the right way, right? That's a rolling quorum. Right, that avoids the intent and the spirit of OMA. So what is formulating public policy? This is that third part of that test. Voting, taking formal action, discussing public business. It's a little bit broad, but really anything where that public body is going to decide something take action on something. They're statutorily obligated to do something. All of those things fall under public business. So let's get into a couple examples. Pursuant to its constitution, the Board of Regents at a state university votes to delegate its authority and decide and approve postgraduate curricula to the faculty senate of the respective postgraduate departments. What do you think? Is this delegated authority to those postgraduate, to the faculty senate? Is that now subject to OMA? See a lot of head shaking. Yes, yes, that is correct. They are now subject to OMA, even though they probably wouldn't be. The fact that they have been delegated the authority of that Board of Regents, they're now making them subject to OMA. So, great. Oh, yes. If they give them the authority to, they delegate that authority to decide those things, then yes, they're subject to OMA for all their meetings. Yes. Example 2. All the employees of the city clerk's office have monthly office meetings to discuss public business. What do y'all think? Is that subject to OMA? No. I hear no's. Good. No, that's not. So these are employees. They haven't been delegated any authority. They just have monthly meetings. They're not subject to OMA. Example 3, the local city council establishes a subcommittee to assist in its procurement issues. When a request for proposal is issued, the subcommittee evaluates the bidders and provides written recommendations to the council. What do y'all think? Is this procurement subcommittee subject to OMA? See a lot of no's. Great, it's not. So even though in this instance they're asking them to help with these things, they are not making a decision. They've been delegated no authority. They're still provided, they're just providing recommendations to the council to vote on. The council is taking action. So oftentimes you'll see this a lot with, let's say, licensing boards. They oftentimes have like a complaint committee or some type of licensing committee that reviews applications, reviews disciplinary matters. They have a subcommittee that deals with those issues. They typically have maybe one board member who sits on that subcommittee because they're an expert, they're familiar with the subject, and they do those things. So that committee is made up of groups of people. That subcommittee is not subject to OMA. However, if you had, say, a 5-person board and they put 3 board members on that subcommittee, it likely would be subject to OMA because now you're creating a quorum issue. So it's important to keep that in mind, that there could be different ways these subcommittees, again, if it was delegated or now they have a quorum. So after several years of operations, the subcommittee's authority is amended by the council. The council now authorizes the subcommittee to select 3 finalists and eliminate all the other bidders from consideration. However, the ultimate decision is still made by the council. A little bit different facts. What do y'all think? Yes, I would say yes too. I would say yes. Now they are subject to OMA because now they've been authorized to eliminate people. They're making decisions on behalf of the board at this point, right? They've been authorized to do that. So I think in this instance, they would likely be subject to OMA. So we've talked a little bit about who's subject to OMA, when does it apply? So when does it not apply? It doesn't apply when you have several things. It's not a policy-making body. It doesn't apply there. There's not a quorum. There's no discussion of public business. It's only a social situation, whether it's accidental or chance encounter. Maybe it's a wedding or something like that. So what are some best practices? Always avoid those rolling quorums, be transparent, and BCC people. So here's a couple examples. 2 members. Oh, sorry. Yes? Oh, okay. So 2 members of a 3-member school board attend a spring football game with the district's longtime superintendent. While at an party, but game, the board members have a long conversation about the upcoming football season. What do y'all think? Nope. I wouldn't say so either. They're just going to a football game. checking out the season, talking about football. Definitely not a quorum, even though they might have a quorum present. They're not talking about public policy or doing any of those other things. How about this one? After the meeting, one of the three board members sends a text message to the other using their personal cell phone, urging him to vote in favor of the proposed budget at the next meeting. The other board member texts back that he definitely plans to vote in favor of that budget. What do y'all think? Are we talking about public business now? Same board. Yep. Yep, I would say yes. Now we've got a rolling quorum. Now they're talking about how they're going to vote, what they're going to do at the meeting. I would definitely say that's a rolling quorum. So I want to go back really quick to this example because there's a practice here that I think oftentimes people do when you have incidental quorums like this, right? Say you know that every year you have a school function that all the board members attend, right? Sometimes people will post a notice of that. They'll call it either like there's a quorum that'll be present, those types of things. And this is kind of an internal debate. OMA doesn't require a notice of a meeting of a quorum unless it's an actual meeting of an open meeting, right? Now, is it a good practice to post these incidental quorums? Sure, you could give the public notice that, right? But if it then becomes a meeting, you're also going to have to post an agenda, right? So I think it's one of those things to just keep in mind, be careful about. It's better to err on transparency because that's what OMA is there for, right? But just keep that in mind that I think a lot of people rush out because they think it's required by them to go post this notice 72 hours in advance of an incidental quorum. Like incidental quorum is just that, it's incidental, right? So there's nothing in OMA that says you have to post a notice of an incidental quorum. Yes. Yes. I would say to err and caution, yes. I mean, you can certainly do that. Like because if you know something's coming up and you have a quorum that's going to be present and it's going to be something on that they're going to talk about at a meeting, like it's just know that it also like, and I think this kind of gets into kind of a weird incidence because if you're posting a notice, it sort of almost assumes you're having a meeting. So you'd have to make it very clear because then otherwise you have to make it an agenda and open to the public. Right? If you're going to tour a private facility, that makes it a little hard because then anybody can show up, right? So keep that in mind when you're doing those types of things. But, erring on transparency, like it's good for people to know that, but it's not, there's technically not a requirement unless they're having a meeting to post that notice. Yes. So great question. The question is whether or not if a member of the board or governing body holds a barbecue for staff, typically wouldn't fall under, it's not, again, same sort of similar situation. It wouldn't be a meeting unless the purpose of holding the barbecue is to, discuss public policy or business. So if there's a quorum that's going to be present, then it would fall under that analysis. Then it'd probably be a meeting. But if it wasn't, and they weren't going to discuss public policy and they're just having a barbecue, a get together, then it would just be what we would call an incidental quorum if people show up. Yes.
At the meeting, that after the meeting is concluded, we're going to be out for lunch. No public.
And that's a great point, and thank you, Sandra, for that example, because it highlights something that I think a lot of public bodies could do, especially if they say they all did go to the same party and didn't know they were going to be there, right? They could make that announcement at their next meeting, say, hey, we were all at this party together. We just wanted to let the public know. that we were there. We didn't discuss any public business. We were there for like this party or this wedding or whatever, right? So it's always a great thing to just err on that side of transparency and kind of let people know that that's happening, but explain why they're doing it, why there's no, you know, public policy formation or anything like that going on. This is an area that has a lot of controversy, I know, lately, remote participation. So OMA contemplates remote participation only in certain instances when we'll call it remote because it's really almost like telephonic participation, when it's difficult or impossible. It does not contemplate only online meetings. Doesn't contemplate that. It contemplates that all meetings are going to be in person. Unless, and everyone will attend in person unless it's difficult or impossible. Now, the question is what then becomes difficult or impossible? Let's say, you know, we're coming up on winter. So let's just say there's a meeting going to be held in, I don't know, late January somewhere, and it snows and someone lives in a mountain and they're snowed in and they can't make it. That would be pretty impossible unless, you know, I don't know, they've got like a snowmobile to get out and then a car somewhere else. Like that would be pretty impossible for them to show up. So remote for that person would likely, you know, be allowable in that instance. So either telephonically, via Zoom, via Teams, whatever, WebEx, I guess, is another one I've seen. So offering that availability to them because it's impossible. If they're in the hospital, it's pretty impossible. I probably wouldn't make someone who's like in surgery try to attend a meeting, but you know, but say like they really, really wanted to because they just have that love of public service. They, you know, that would be pretty hard or impossible for them to make that meeting. So having them call in makes sense, right? So, but otherwise, the intent is for everyone to attend in person. So, and we'll talk a little bit about OMA notices later, but a lot of public bodies today have remote viewing, either live recording, they do it on Teams, they do it on Zoom, and then the question becomes, okay, well, what do we do with the public comment period, right? And we'll talk a little bit more about public comment, but if you're going to have remote participation, you know, there's a few things to keep in mind, but public comment should be allowed, right? So if public comment, and I'll go into this in a minute, but specifically in OMA, it says attend and listen. That's what's afforded the public. But if you're going to have a public comment period in the agenda and you have it on Teams also, you should likely allow those people on Teams afforded the same right to make a public comment as those who are going to attend in person. So just keep that in mind, that extends to if you're going to allow that remote access for public as well. But our general advice is members of the board must attend in person unless that's difficult or in person. I would say also a good, yes.
He decides he's gonna go to Arizona for 6 months and would like to participate remotely from Arizona. Nothing necessarily drawing them there other than the convenience, the weather, maybe some family, something like that is, and it, you know, it is maybe inconvenient for him to travel back from Arizona to Mexico.
Mm-hmm.
Well,
so, and I'll say this and I'll preface it that the way that our division typically interprets it is mere inconvenience isn't enough, right? So if you got to drive 2 hours out of the way, right? People did that tons of times during COVID, right? So I think, or before COVID. And it wasn't until those public health orders that came out that we kind of moved to this other type of system. So OMA doesn't contemplate that. what you're stating, right? So difficult would be like, and oftentimes it depends, right? So a lot of boards determine their meetings a year in advance. If you know your year in advance that these are the dates that you're going to be expected to show up at the meeting, right? Then it's not necessarily unreasonable to think like you should schedule around that if that's what your job, part of your job is, right? If you're going to be on these boards. Does that make sense? But I think one of the things to keep in mind is oftentimes, especially with, a lot of commissions and boards around the state, is they are working, full-time working, they have full-time jobs, right? So they typically often own their own companies and run that day-to-day business, right? So I think it's understandable that sometimes people can't make it. So ultimately I guess where I'm going with all this is the discretion becomes to the board's staff, but our typical interpretation is they must be in person. We would deem difficult, like in that travel example, say someone went back to Italy because they had a family emergency, right? Would it be reasonable for them to get a flight back from Italy to come to a board meeting for 2 hours and then go back? Well, that's a lot more difficult than 6 months in advance you got to be here for a day or 2 days, right? But I think so that's kind of where that line comes into play. There's not a whole lot of case law there, but that's kind of how we typically look at it. Yep. So, and we'll talk a little bit about the OMA notice, Open Meetings Act resolutions in a minute. Public access is not required, but typically encouraged as just a best practice. Physical location is required by OMA, not a virtual location, so keep that in mind. Full virtual is not clearly allowed by the law. That public health emergency has long ended, and it is not in effect. If there are going to be people participating remotely, please have those members announced that they are going to be remotely. They must be audible when speaking, and the votes should be by roll call if there's any confusion of the vote. So typically best practice is if you're going to have some type of virtual participation, do a roll call on votes so people know who is actually voting for what. Reasonable notice, every public body must determine what notice is reasonable for it. That determination must be made every year. Oftentimes you'll see that as called the OMA resolution, and I believe we still have an example in our OMA guide of what one looks like. It includes methods of time and notice. Best practice is just get it right done out beginning of the year. This is what our OMA resolution is for 2025. Here's where all our notices are. This is how we're going to post everything. This is when our agendas are going to be posted. Our best practice is 10-day notice, 72 hours for that agenda, but 10 days for the notice of a meeting. Excuse me. So that's our best practice. So what is actually required in that notice? It must be posted in a public location. What does that mean? Similar to IPRA, if you have a website, please put it on your website. If you have a physical location, definitely have that in the physical location. Sent to broadcast stations and newspapers that have requested it to be in there. Unless either your rules or statute or your OMA resolution you elect to publish in a certain newspaper, the only time it's actually required is when someone has requested that notice be published in their newspaper. Posted at least 10 days before, that is our recommendation, and then 72 hours, what we call special meetings. So if you have set 4 meetings a year and then you decide you need to make an extra one, we would call that what's called a special meeting. So you would just have to, best practice is 10 days before if you can, but if not, 72 hours ahead of time. But it is up to the public body to determine what is reasonable as long as it's within the OMA guidelines. So as again posted on the website, emailed to anyone who's requested it. public entrance of the office, or where the regular meetings are held. So it needs to include the date, the time, the physical location of the meeting, and the agenda or directions on how to obtain a copy of the agenda. So that is what is actually required within the notice itself. I'm going to skip this slide, but just note that there are some instances where the agendas and notices may need to be published in English and Spanish, depends on the communities that you're in. Agenda requirements, 72 hours prior. List of all specific items of business posted to the website if maintained. And you cannot take action if it's not on the agenda when it's posted that 72 hours. So, you know, and I want to see if we'll get into this, but it does not require a statement of closed session, although it is good practice to have that in there if you know you're going to go into closed session for items. But it is not required under OMA as long as a reasonable or the proper motion under OMA is in there. There are exceptions for emergency meetings, which we'll touch on in a little bit. Public comment, again, is not required. I will say that if you have had public comment on your agenda for the last 20 years, and then you decide to take it off because there's a controversial topic, just know there is some case law that probably won't allow that. So just keep that in mind. Closed session language, again, is not required, but is highly encouraged. Yes.
Purpose, they can do that without that being stated on the.
Yes, so the option of a closed meeting is just that. It's an option. So they can enter a closed session as long as it's following one of those exceptions to enter closed session and there's a proper motion. Oftentimes, if, like, I'll give the litigation example. Say the board wants to talk about a certain case that's pending, right? They know they're going to go into closed session to have the discussion about that pending litigation. It's best practice to say, you know, this would be a closed session item under the agenda with that exception listed. You know, we may go into closed session to discuss this agenda item under this exception, right? But as long as that motion is made, you can go into that without that on the agenda itself.
And I'm assuming then if they decide to go into closed session, and it's not on the agenda, then there's no requirement that there be a whole lot of specificity around that other than in the motion to close the session. You see what I'm saying? I mean, if you put it on the agenda,
so
to go into closed session, do you need to put any specificity as to, let's say it's for personnel matters or litigation? Do you need to put anything as to the specifics around that?
Yes, so personnel matters is not an agenda item.
Okay.
So like, and we'll have an example of that here in a minute. But yes, you can't just say litigation because the area of the part of OMA that talks about what the agenda says has to be reasonably specific for the public to understand what is going to be discussed, right? So for example, if you say personnel matters, we have no idea what that's going to be, and then you just have that entire part in closed session, no one knows what that is, right? So like if you say the hiring, firing, dismissal, evaluation of the director of the board, that's pretty specific. Everybody knows you're going to be discussing those likely outcomes of the director of the board, right? Then you can move into closed session because it would fall under that exception of personnel matters. Does that make sense? Okay. So it's not required necessarily in the agenda. So oftentimes what I see is people will have on their agenda closed session. That's not an agenda item, right? So you'd have to put like disciplinary matters. So for licensing boards, a lot of times they'll put disciplinary matters and then they list out the matter numbers because internally they have matter numbers assigned to protect the confidentiality of those people, right? That's a closed item, closed session item. So they'll put disciplinary matters. The board may enter closed session under exception, blah, 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 to discuss these disciplinary matters under agenda item, blah, 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 right? So it's not required to be on the agenda because it's an option. So for example, if they wanted to discuss all those disciplinary matters in open session, they can. totally fine. They don't have to have them in closed session. It's an option to have it. Yes, yes.
that. Is that sufficient, or do you have to list out every provider or every position on the agenda that would need to be, that you're considering?
So the question is whether specifically, we'll defer back to y'all for whether it would fall under this exception or not. But depending on what it is, if you're talking about like say application statuses or things like that, the question is whether those have to be listed out, right? So you would say approval of applications or approval of certifications, right? If you have matter numbers attached to them, it's highly encouraged to attach those matter numbers in the agenda, and then you can just go through them and approve them.
Usually, we're credentialing privileging a number of people who finish the credentialing application process, and now the board has to approve them by law.
Mhm.
And so, I'm just curious if we have to list that out on the agenda, or can they just say this is what's being discussed and then come out of closed session to approve them, which they would have to do, and then read the names off. Is that satisfactory, do you think?
So the question is whether, so let me ask a clarifying question, because the question is, on the agenda, what does your item say?
Says for the section of approval, credentialing and privileging of medical staff.
Okay, so the agenda item would be credentialing and privileging of medical staff. And then you're entering into an exception.
Closed session. Usually the chief medical officer would give a description of what the credentialing committee found in executive session to the board. And then they would come out and then they would approve or deny the credentials.
And they would say the names then.
They would state their names.
So my question is why, I guess it's a two-part question. So the question is, if you have that agenda item and then you go into session to do that, and you come out and make the decision to credential them and you're saying their names, right, out in person. So it's sort of a two-part question. I would say, is it reasonably specific? The agenda item would have to be reasonably specific to determine that. One, like, would the public know what you're talking about, right? Number two is, does it fall under one of those exceptions that we'll talk about here in a minute? And then if it does, and you come out and you're taking action on it and you're stating the names, I guess my question would be like, so oftentimes, like when we get barred for the bar license, right? We know they post our names. It's a public part, right? And they make that choice, right? And so I think my question would be, if you're able to publicly state it after the fact, why wouldn't you have it on the agenda?
Many times, probably because it's a long, lengthy list.
Mhm.
Other than that.
Okay. Okay. Yeah, it'd be something that'd be specific. Go ahead, Sandra.
It's a CMS.
Mhm.
So question is, should the public be ahead of time? You can make a comment.
Yeah.
If you're going to be announcing names, not put them on. Want to make
Mhm.
about these.
If you, because sometimes it's just, again, it gets. So
Well, and
we've got to do not just new appointments, but reappointments of medical staff. So could you put an attachment? Could you put that item on there and say, refer to attachment A and then list them all out?
yeah, I don't see why you couldn't do that. Like Appendix A, yeah. So yes, yeah. No. It's good questions. Sure, yeah. Okay, so let's get into a few examples. The school board secretary is responsible for putting out agendas every meeting. The next meeting is scheduled for Friday, 5 p.m. So Sue puts out the agenda at Tuesday, 5 p.m. The next morning, Wednesday at 8 a.m. Sue realizes she forgot to put on this contract item on the agenda. Show of hands who thought they do math today. No one? Okay, well, we are doing some math. It's hopefully not too hard, but I'll go ahead and walk through this one. Friday, 5 p.m., 72 hours. So let's just go back. Okay, Thursday, 5 p.m. is 24. Wednesday, 5 p.m. is 48. And then Tuesday, 5 p.m., 72 hours. Perfect. Okay, so we're good on that front. Okay, next morning, Sue realized she forgot to put a contract on the agenda. What do y'all think? Can Sue now add that item on the agenda? No. No. So unfortunately, Sue missed the deadline. Can't add those onto the agenda. So yes. So Sue could add it to the next meeting's agenda. Yes, that's correct. But for this particular agenda, this item has been left off entirely, so there's not proper notice.
Then like a more of a general agenda item.
So
You
the
can add things you forget.
So the question is, can they then add a general agenda item? The answer is no. It has to be reasonably specific to understand what is going to be discussed at the meeting. So now, I will say, I will say to your point, say Sue said, I added, contract. Let's say I added this, she had added this contract on the agenda item, and the dollar amount she put on the agenda item was $5,200, and it was a typo and she meant to hit $300, right? Now they could amend the agenda likely at the meeting to say, hey, this is a typographical error. Still the same contract, still an amount, but just so we know, and then vote on it as amended to correct the typographical error. So, okay, here's an agenda. Example agenda. We have a call to order. We have approval of the meeting agenda. We have approval of the minutes, old business, new business, vending machines in the cafeteria, limited personnel matters, and adjourning. What do y'all think? Is this a good agenda? Does this give notice to people? I see a lot of people shaking their heads no. So, okay, great. That's great. This is not wonderful. We have some notes. So the board discusses and acts on 3 contracts. Was the agenda reasonably specific? No. Business discusses and votes on allowing vending machines in the school cafeteria. Well, we don't know that. It just says vending machines in the cafeteria. Well, we don't know what that exactly means. Limited personnel matters. While this is an exception, we don't have any idea of what that means. We have this one, which still has limited personnel matters on there, but now we have the evaluation of superintendent's performance and action on renewal of contract with an annual raise. They intend to enter closed session, evaluate that. Are there any OMA violations? We kind of went over this, so it's not necessary, but if they intended to go into closed session, best practice is to have that stated in there. As long as they're following the proper motion, though, that's okay. So minutes. This is a hot topic. I think I get a lot of questions on minutes. Minimum requirements are the date, time, and place, names of members present and absent. Please note whether those people are virtual. That helps the public. Substance of any proposals considered, the record of decisions made and any votes. Now, this is what's required. These are the minimum requirements. I've seen a lot of minutes where I promise some of the public could be like published authors with their minutes. So like they're like 19, 20, 30 pages long. They're like full dictation of everything. You do not have to do that. You don't have to do that. As long as it says date, time, place, names, substance of proposals considered. So maybe there's some discussion about it that you want to note, but just the substance of what's being considered and the votes and the decisions made, that's sufficient. We don't have to have a full dictation of what happened. So available within 10 working days. Yes, this includes drafts. That does not mean, so if someone requests the minutes on working day 11 and you have it in draft format, you have to give it to them. So even if they IPRA it, please don't use IPRA as a reason to wait 30 days to give them the minutes that you're supposed to have 10 days after the meeting. So just keep that in mind. It does include drafts. Oftentimes people will say, well, it's not approved by the board yet. And it's like, okay, it doesn't have to be. It has to be the draft. Those meeting minutes have to be approved at the next meeting. Next meeting. So if you have a meeting quarterly and you decide to have a special meeting in between, that means those minutes have to be decided at that special meeting. Doesn't mean you wait till the next one. You can't table decisions on minutes unless people find a bunch of errors and they're not going to approve it and they need to amend it. Avoid transcript style minutes and post the draft on the websites. That's the best practice. Although not required under OMA, it is just something we recommend. So here we go. Here's some examples of minutes. A member A moved to approve the minutes from the board's July 21 meeting. Member B seconded, a vote was held, and the motion was approved. Member C moved to adopt the Open Meetings Act resolution, and member D seconded, vote was held. Members voted unanimously in favor of the adoption. What do y'all think? Which one is a better minutes? Second one? Yeah, I would agree with that. It's a lot more specific on what they're doing. You know, that tells who while this one says seconded, a vote was held and motion was approved, it doesn't say what the vote looks like. This one says it was voted unanimously in favor of adoption. So we know how people are voting there. Okay, emergency actions. Emergency actions, this is something that is actually dictated in OMA itself. It's very specific. It's unforeseen circumstances that, if not addressed immediately by the public body, will likely result in injury, damage to persons or property, or substantial financial loss to the public body. I'll give a really good example. The fires that have happened, or the flooding that happened in Roswell, those are emergencies, right? If the bridge gets wiped out, right? They need to make a quick decision. That's an emergency. That would qualify for an emergency. Hey, we got we sent out a job offer. We'd like to vote on this person, so we're going to hold a meeting tomorrow to approve them. I would say that's not an emergency, right? That can happen at the next meeting. So public body may authorize emergency response without convening the meeting, as long as there are quorum and majority currents required to authorize that response. So as long as they're still having that quorum and a majority is voting on that item, they don't have to follow the typical guidelines of OMA. They have to follow what's under the emergency, which is typically 24 hours. If there ever is an emergency meeting, you must report it to our office afterwards. What was discussed? What was the vote? Are there any minutes? Those types of things all have to be sent within 10 days of that meeting to our office to review. Any quick questions on kind of the open meetings, special meetings, emergency meetings before we get into closed session items? Correct. Only emergency meetings. So closed meetings, not required, but discretionary. They are only allowed under the 10 exceptions listed in OMA. Unlike our IPRA presentation, there is no catch-all part. So please keep that in mind. So that's where that no otherwise provided by law. It has to fall under one of those 10 exceptions. That it's only discussion. Any votes on those items has to be done outside of closed session. So it has to be done in the open session part of the meeting. So closing a meeting, there are certain requirements. Agenda item must be subject of one of those 10 exceptions. The motion has to be done and states the legal exception and authority to enter closed session and the agenda items and topic to be discussed. A roll call vote must be taken. And the minutes must include a statement regarding the closed session. That statement has to be, and then when you come out of closed session, the public body should state, every item discussed in closed session under agenda item A was a discussion only and no votes or items of the discussion was taken. Consider whether closed session is necessary. Follow a motion script. That's typically best practices. Most boards and commissions I've seen have a script that they have for following motions. And make a statement on the record after the closed session similar to those minutes requirements. So that minutes requirement is what's required that says, you know, every item discussed was a discussion only that fell under this agenda item, under this exception. We took no action on this item. So here's some examples. So the chair, I'll enter a motion to entertain a motion to enter closed session. Member 1, I move that the board enter into closed session. Member 2, I second. The chair, the motion to enter closed session has been made and seconded. Any discussion? Seeing none, all in favor say aye. Aye. Now they're in closed session. What do y'all think? Is this the proper motion to enter closed session? What do you think? I see no's. Okay, no, that's correct. It's not. We have several items here and we'll go into a better motion here in a second, but motion did not state either the legal authority for closure or the topic to be discussed, and there's no roll call vote. So here we go. I'll entertain a motion to enter closed session. I move that the board enter to closed session as authorized by the licensing exception of the Open Meetings Act to discuss the disciplinary matters as listed on the agenda. Seconded. Okay, any seconded, any discussion? May we have a roll call vote? They take a roll call vote. Now they are going to enter closed session and let the record show that they entered into closed session at this. Then they turn off the record. Much, much better. This looks like a really good, proper motion and procedure to enter into closed session. Closed meetings minutes. Minutes from an open meeting must state matters discussed in closed session were limited to those specified in the motion to close. If there is an actual closed meeting that is held, the minutes of the next open meeting must state that those matters discussed during that separate closed meeting were limited to those specifically listed in the notice of a closed meeting. So before we get into kind of the exceptions, I want to say that on closed session, it's always good practice to note that, but keep in mind if you are going to have virtual options and you are going to discuss things in closed session, it's a good idea to make sure, A, you stop recording and make sure people don't have access to that. Sometimes that can get inadvertently done, so just keep that in the back of your mind that you need to do that if you're going to enter closed session. So OMA exceptions, as I said, there are 10 of them. We'll go through a few of these that we see more often: issuance, suspensions, renewal, limited personnels, deliberations, personally identified student information, collective bargaining. So some of these are pretty specific and applicable in only certain circumstances: purchases exceeding $2,500, pending or threatened litigation, purchase and acquisition. And then I don't know if anyone is here from the Gaming Control Board, but they have their own exception. So limited personnel matters. We won't go through all of these exceptions here. We'll go through some of them, but limited personnel matters we've touched on quite a bit today, but it's that discussion of hiring, promotion, demotion, dismissal, assignment, resignation of, or the investigation, consideration of complaints or charges against an individual public employee. This is where it's really good to understand that it does not cover general personnel policy. It is limited to individual employees. So if your agenda item said any of these things, discussion of hiring, promotion, etc., of executive director, that's a specific employee. That's good. You can go under that discussion under the limited personnel matters. So you would make that motion that it would be under 10.15.1H2, limited personnel matters, and you would do a roll call vote and you would enter into that discussion to discuss the hiring, promotion, demotion of the executive director. So you do not need to specify, you do need to specify what the employee is on the agenda, either by name or position, but you don't have to say their name. If it's a position, that's fine. It does not preclude a aggrieved public employee from demanding a public hearing. Any final action on this discussion must be done in an open meeting, as all of these are. Administrative adjudications, it covers those deliberations in connection with administrative proceedings, for any types of legal rights, duties, privileges required by law. The hearing must be public unless otherwise provided by law. So separate from the hearing, this is just the discussion of it. Litigation. This is an exception that I think a lot of people sometimes misconstrue. This is pending or threatened litigation. It involves those that it does not involve things that are just attorney-client privileged. There is not an exception for attorney-client privilege under OMA to go into closed session. So this is for litigation, and so it only is dealing with things that are either ongoing, a credible threat, or the public body is initiating a lawsuit. It doesn't mean just whatever y'all want, right? So it can't just be like, well, we think this lawsuit might happen at some point in time. You know, we have no idea. It could be 20 years from now. That's not really pending litigation. That's not threatened litigation. So it really just means these things: ongoing litigation. Some public bodies have lots of ongoing litigation. If there is a credible threat, maybe someone is threatening to take action against you, can have that discussion with your attorney present. Or if you are trying to initiate your own lawsuit, that is when this exception truly applies.
That would be allowable.
So the question is under this exception, sometimes there may be an executive director or a CEO who's giving updates on pending litigation. I would say that if that person is going to join you in litigation to give updates during that exception, I would let it be known that they're going to be giving updates on it. But typically, you know, if that's the person you have doing that, but typically I would say mostly I've seen attorneys give those updates, in-house counsel, things like that. Yeah.
HR works with our attorney on the
Sure.
employee litigation, it could be medical malpractice things.
Sure.
She's usually the one giving the update. Or and again, I would think how specific do you need to be under this clause? Can we just say risk management update? Is that?
Well, and so this is and the question is how specific do you need to be in the agenda item? So I'll give you an example, right? Let's say I know there's a lawsuit out there. It's out in the public, ABC versus my public body, right? Well, if we're going to discuss ABC versus my public body, and that's going to be the agenda item, you could say update on ABC versus my public body, right? But for example, if you're talking about initiating a lawsuit, I mean, that's a little more vague, and that you might want to like have that strategy protected a little bit because it's not a public lawsuit at that point. So there's a fine line there. And I think, you know, having counsel, you know, coach you on kind of what does that agenda item is. Does it meet that reasonable particularity of what needs to be done under OMA to have the public understand what the discussion is going to be what we would look at. So, yeah, but we understand that there may be some instances, especially here or here, where it might have to be a little more general to just kind of protect some of that privilege and confidentiality of things. So, yeah. is there a question online? Oh, okay. Y'all were looking at me like there might have been a question online. Okay. Okay. Great questions. So those are the exceptions that we kind of like to highlight. Some of the other ones are very, very specific. And I'm happy to answer additional questions on those. If there are invalid actions, so anytime an action is taken in violation, it may be deemed invalid. The presumption here is that the public body complied with OMA. There is a cure process within OMA that if there are invalid actions taken, that they can cure that invalid action at the next meeting. So just keep that in mind. So, and then we're getting towards the end here. Enforcement, there are civil and criminal penalties. The Attorney General and the district attorneys are statutorily obligated to enforce this. Again, the presumption is that the public body is acting in accordance with OMA unless there's evidence to prove otherwise. Private individuals can take action, written notice to public requirement. The public body has 15 days to act on the alleged violation. An individual can recover any reasonable costs and attorney fees. It is a misdemeanor to violate OMA. That's the criminal penalty, and it's $500 per violation. So not nearly as expensive as IPRA, but can get kind of costly if you have 30 items on your agenda and you violated it 30 times. So something to keep in mind. Yes.
Could be the cost that if you had a board member who wasn't necessarily difficult to attend, but they didn't feel like driving up from Plus Texas to attend the board meeting, could it be that the actions that the board took during that meeting were invalidated because they didn't have a reasonable reason for not being?
It's a great question. Great answer.
Struggle is, there's a gray area there. What's that distance?
Well, and
Because we have one, to be honest, we have one now that, chooses to spend his winters in Arizona. Well, that's going to be probably 8 to 10 hours. And I know they would prefer to participate remotely.
sure. And I think so the question is what does that difficult mean? And certainly there's some case law on OMA, but not nearly as much OMA case law as IPRA case law. But I would caution people to say that, if you know 12 months in advance that you have a meeting and you're going to purposefully miss it or purposefully schedule something to attend remotely because you know you're going to spend that 6 months, it's pretty reasonable to understand that you could, instead of drive 8 hours, you could fly 45 minutes, right? So there are things like that I would caution public bodies to keep that in mind. So, yep. So, and it goes kind of back to this very first point, is always err towards that transparency. That's the intent and the spirit of OMA, is to provide transparency to the public and provide them with the greatest information possible of what we're doing. So always err towards that. Avoid rolling quorums. We talked a lot about that. Agendas must be reasonably specific. Closed session is only permissible if the exception applies and you follow those specific procedures, but it is up to the board to determine whether they want to follow that. Action in closed session cannot happen. It must happen in the open session, and provide more notice and public access than minimum requirements in OMA is always a good practice. Avoids those costly penalties in any violations or things that you have to cure. So that's in review, and there's questions I have in break because a lot of times we do OMA first, but we started with IPRA today, which I'm very happy about. Usually once we get to IPRA in the afternoon, people fall asleep. So, okay, so if there are any questions, please feel free to ask. I'll take a few here, but if not, thank you for coming. Yes, we have several. Go ahead and start here.
I appreciate
Absolutely. Thank you. Yes. The exception for a limited person? Yes.
Issues with maybe director or city employee within the district.
As long as they have authority over that person's employee. Yeah. Yes. Yes. So, and sorry, let me repeat the question for those folks on. I try to remember that, but so the question was, is that the public body specifically has authority over the superintendent, but not other people that are in the employee? Does it only include the superintendent? The answer is that it includes those that you have direct supervision over. Yes. Yes, in the back. So the question is that they're not a public policy making body, but they were created by statute. I would say yes, the Open Meeting Act does apply to them, yes. Can you explain that a little more? Ah. Yeah, so the question is they receive federal funds and they have an advisory committee that advises this other group on federal funding. I would say that if it's something the committee or the board approves, but they're not delegating that authority and they just have a subcommittee to review those and bring them there, I would say no, that separate advisory committee wouldn't necessarily fall under that. So the question is, are the people there, everyone's around state and not meeting in person? Yes. Should meet in person, yes. So, and I will say this, that, you know, there is for example, I'll give the example of law enforcement boards because they deal with people all around the state. So they try to have their meetings at different academies and things like that around the state to accommodate that travel, right? Where that shouldn't happen, for example, is like towns, right? If you're a local town body, you shouldn't be, and you're in like, you know, let's say Farmington, like probably not best practice to like, hey, let's go meet in Las Cruces, right? That's not great because now you're the city council for Farmington, and you know your expectation is you're providing that public involvement and you're going to have a meeting in Las Cruces. That doesn't make any sense. So, but from that instance, if you have that, you can consider travel kind of might be an option if that's something to accommodate. Are there other questions? Yes, we got a few more questions. I'll start with you right there. Yes. Great question. So it's a two-part question. The question is, what's the procedure to enter back into open session, and is there a roll call vote required to reestablish quorum? So first question is, yes, the board should make, you know, just state the same thing as the minutes, that, you know, we discussed these items in closed session. We're now entering closed session at blah, blah, blah time. No matters were voted on within this closed session. And then but we're now entering open session. So I think you could make a statement similar to that. Do you need to have a roll call to enter from back into open session from closed session, you do not. It's not required. But if you have lost your quorum in the meantime, then that means that you would not be able to take action on any of those items. So I know sometimes people, depending on the board, may do closed session items up front, because oftentimes if there's like conflict scheduling or things like that, and people have to leave, they'll want to get those voted items on up front on their agenda so that they can have informational items on the back end for that reason specifically. Yes. You can have a meeting, but you can't vote on anything. So that's where, like, again, if you have like people coming to do presentations or reports or informational items, you can still have those informational items be presented. You don't have to stop the meeting. Good questions. We'll have one right here and then we'll come to you. Yes. Great question. So the question is, our best practice is 10-day notice for meetings. If you notice all of your meetings up front at the beginning of the year for the rest of the year, is that sufficient notice? I would say that typically, if you're going to say our meetings are held on these specific dates at these specific times at these specific locations, you've met that notice requirement for that meeting. Does that make sense? For the year. However, if that's going to change, right, then you should be following what's required under your OMA resolution and what your notice is. So I think reminders are great. Just keep in mind that the agenda still has to be posted as well. Yes. And sometimes people do that. Like oftentimes, like a great example is like the public school system. They have their meetings like the first Tuesday of every month or whatever at the same place, the same time, etc. So they kind of notice those similarly. So then we had a question there. Yes. Yes, and it's a formality, and it's generally so. It comes from best I can tell, mostly past practice, and it's good advice. So most boards follow what are called the Roberts Rules of Order, and so it's not specifically stated in OMA, but it's an acknowledgement of the fact that the board has reviewed it and approved it. So, for example, if they wanted to say take something off of the agenda, they could have that opportunity to do that. So yes, good question. And I'm sorry for those folks online, I don't know if I repeated the question. The question was there a formal reason to vote on the agenda ahead of time during the meeting and take a vote? And the answer is not necessarily. OMA doesn't contemplate it, but Robert's Rules of Formality typically do that to offer the opportunity to take things off or amend it to some degree. So yes. Yes. No, so OMA doesn't, it's 72, so the question is does the 72 hours posting for agendas happen for meetings and special meetings? Yes, it's always 72 hours. OMA doesn't contemplate special meetings. We just, those that are not, typically most boards plan them out, their regular meetings throughout the year. So we call them special meetings if there's something else planned, but you still have to follow all the same requirements under OMA. Any other questions? Any questions online? Nope. Okay. Well, thank you all so much for your time. We really appreciate y'all coming out.